please stand by. We're going to turn things over now to Michael Coyne, who is an associate dean at Massachusetts School of Law, who's on the phone with us. Really, it was a split thing here, Michael, where some people thought for sure he's going to take the stand, while other people said no way, he's never going to. And now we know Whitey Bulger will not be taking the stand in his own defense, though according to our reporter in the courtroom, he probably wanted to a little bit and now is saying he's being guided to do otherwise. What would you have done in this situation? Were you his defense attorney?
I agree that he shouldn't be testifying at this point. I don't think he has anything to add with respect to the judge's ruling on immunity. Really foreclosed that door from him being able to tell his full story. Not being able to tell his full story really just puts him up there to tell a very small portion of it. And I think the defense has likely established what they were seeking to do at the outset, which is to show that the thin reed of evidence that supports him being an informant rests largely on corrupt FBI agents and their testimony and their earlier testimony and the like. And so he's established that part. He has created some level of doubt with respect to whether he or Flemmi killed Deborah Hussey and Deborah Davis. If he can't tell his whole story, then the mystery and the myth and the legend of Whitey continues by his silence. And I think that's what he was hoping to accomplish, and perhaps he has, by refusing to take the stand, taking his fifth, which is his constitutional right, and allowing the mystery to remain.
Michael, stick with us here. I just want to update people from our reporter in the courtroom, Alicia Palumbo, tweeting something interesting, which we forget because we're not in the courtroom, which is the jurors were not in the courtroom when this decision was made, when J.W. Carney told the judge that Whitey Bulger would not be taking the stand, when there was an outburst from someone in the peanut gallery, one of the family members of one of Bulger's alleged victims, shouting out, "You're a coward," and some of the things that Whitey Bulger himself has said. Alicia tweeting that what he said, Whitey Bulger, was very measured and that his Boston accent was very clear. Now, Michael Coyne, a Massachusetts School of Law associate dean, on the phone with us. I'm curious to know, do you think that the defense ever thought, I mean, we don't know which way this case is going to go, but there's a pretty strong likelihood that he's going to get convicted. Do you think that they feel like they have a chance? I mean, why wouldn't they consider having Whitey Bulger take the stand?
Because the standard of proof is so high in a criminal case, is all the defense has to do is show that there is some level of reasonable doubt. The fact is, there is ample evidence of the extensive government corruption in this case. There is some level of doubt with respect to who the murderers were on some of the victims. And if the defense is able to simply have one juror hold out with respect to feeling that the measure of proof isn't beyond all reasonable doubt, then in fact they have a deadlocked jury, which is a mistrial. And a mistrial means that Whitey wins. He wins for another day. He's not convicted of these charges. It's a long shot, but the fact is with the story that we've heard at various times, even through the defense questioning, there isn't a lot of doubt that some of these charges Whitey is likely guilty of. In essence, that there have been questions at times that start with, well, he ran an organized crime ring. So there's no doubt that to some extent he was a crime lord. He's banking on that a juror, or more than one juror, will find that the level of government abuse in this case may be enough to create that doubt, to establish some level of reasonable doubt.
Well, as you point out, a long shot still makes it a distinct possibility. I think something else that the defense was pushing for earlier this morning in talking to Judge Casper before the jurors were brought in, I think they were asking that the jury be explained what accessory after the fact meant, and the judge said no, she didn't want to do that. What would that have done for the defense?
Just simply given them a lesser included charge as opposed to some of the murders. Again, what he's been trying to establish is that the deaths of Deborah Davis and Deborah Hussey were much more likely at the hands of Flemmi, who had a greater motive than Whitey. And what he was hoping, what the defense was hoping to establish, is that if he was found guilty as an accessory after the fact, then in essence he's established that Flemmi committed those murders, not him.
11:06 right now, and we're on the phone with Michael Coyne, Massachusetts School of Law associate dean, as we just got word a few minutes ago that Whitey Bulger will not be taking the stand in his trial. Also getting word here from Alicia Palumbo, our reporter in the courtroom, that closing arguments are going to be happening come Monday, and that Tuesday the jury will be given instructions. Michael, what kind of closing arguments do you think we're going to see from the defense and the prosecution here?
Well, they've each been allocated 3 hours of time to present their information. And what you're going to see is a recap of the 5 weeks of testimony at this point. And you're going to see the evidence, the pictures, the drugs, not the drugs, but the money, the guns, the numerous weapons that have been introduced in evidence by the government. And you're going to see all of that laid out for the jury and tied together. From the defense's standpoint, we're going to see what we've seen over the course of their cross-examinations and the case that they put on this week, which is that you can't trust the FBI or its agents in this case, that there is extensive, widespread government corruption and that Whitey bought and paid for agents, and not just FBI agents, state police officers, and that there is sufficient doubt about the veracity of the files and the testimony and the evidence that hopefully they will find him not guilty of the numerous charges that he faces. It's as we've said, it's a long shot, but that is their case and has been their case. And particularly, I think what the defense wants to establish, and Mr. Bulger wants to establish, is what he has said all along, or what they've claimed all along, is that he lived by a certain code, and that code included that he wasn't a rat and he wasn't a woman going to kill women.
It's interesting the things you get hung up on when you're in a situation like this. Last question before we let you go, just briefly, with all of the evidence and the fact that this case has stretched on for 30-plus days, how long do you think the jury will deliberate before we get a decision from them?
Yeah. You know, the experts are torn on that. Some say they could be out as few as a day and a half, and others are saying it could be 5 to 7 days.
Okay, so
if I had to guess, I think we'll have a decision by the end of the week. So maybe sometime late Friday we would see a verdict in this case. If the jury takes their time, goes through the 33 separate charges as they will be instructed to by the judge, it could be much longer. But they may want to get home early for the weekend, and we may have a verdict by late Friday, would be my hope.
They could be motivated. Michael Coyne, Massachusetts School of Law Associate Dean.